Another lawyer in the building just asked me this question, so I think it'll be a good idea to put this down in a video. Some people think that having a last will means that your family is going to avoid probate court, and the truth is exactly the opposite. A will guarantees probate court. In Florida, that can cost your loved ones time, money, and their privacy. So this video is going to quickly go over what those are, what those issues are, and how to avoid them. Probate court is kind of like bankruptcy court for dead people. It supervises the process of liquidating your assets, paying your debts, and then distributing your assets to your heirs. If you don't have a will be provided for you by Florida. That's their default rules. It's kind of like estate planning Miranda rights. In Florida, you can draft your own will, and the court will follow your instructions and follow instead of following Florida's default will for you. The court will validate that that will is actually a true, valid will, that you haven't replaced it with another will after that. Your will appoint who the personal representative of your estate will be. Some states call that the executor. Florida calls it the personal representative. And then the court supervises the entire process of administering your estate. There's nothing inherently wrong with probate court. I draft a lot of last wills, and when that's the appropriate solution for my clients, you just have to understand what the problems are and then deal with them or avoid them. And here's what probate court will generally mean for your family. First, it's a slow process. Even a simple probate can take 6 months to a year, more likely a year. And if you have difficult to liquidate assets, then it can take even longer and be more expensive. The personal representative will hire a probate attorney. That probate attorney needs to get paid. Often they get paid a percentage of the amount of the assets that are going through probate. So that's usually 1 to 3%, depending on the types of assets that are involved. And third, it's a public process. When your will gets filed, everyone can see it. People can see, who's getting what. Every distribution that is made is a matter of public record. So nosy neighbors and predators or scammers can see exactly what your loved ones are going to be inheriting from your estate. The good news, however, is that you've got a lot of options for avoiding probate. The Gold Star option is a properly designed and funded revocable living trust that bypasses probates for all of your assets entirely. Your assets then transfer privately directly to the people you've chosen without any court involvement or delays and without having to hire a probate lawyer. Unlike a will, a revocable living trust will also work if you're incapacitated. Wills only work when you're dead. A revocable living trust lets you appoint a successor trustee to administer your estate while you're still alive, but you need help. And so they will be in charge of essentially paying the bills and keeping the lights on and taking care of you. If you already have a will, then that's better than not having anything at all. At least you know your assets are going to go to whoever you listed in your will. But don't assume that you're protected from probate. There's a lot of other asset by asset techniques that can be used to avoid probate, and I've put those together in a free Florida probate avoidance checklist. Just contact go to my website and gaganoffice.com and contact us and ask for the Florida the Florida probate avoidance checklist. And we'll just send that out to you. It's a free resource. And of course, if you want to talk to me about what kind of solutions would work best for your family, I'm happy to have that talk with you. That's what we're here for. We're here to help good parents who worry become great parents who plan with plans that actually work when you need them the most. So see you until the next video.